Okay, Assalamualaikum warahmatullahi wabarakatuh, my friends Nurin and Afif. So, as we planned today, we are going to discuss about the case of Phang against Hock. Okay, so this is the citation of this case where the appellant is Phang and the respondent is Hock. The timeline in this case is very important. Okay, on 20 December 1944, that is a time during the Japanese occupation in Malaya. Okay, so on this date, the appellant's husband, Phang, the appellant's husband is Hock, has an agreement with the respondent, Hock, and paid for $20,000 to get the interest of the land that transferred from the respondent to the appellant's husband. However, 2 years later, on 13th February 1946, the appellant's husband died without stating any will for his wife, so that the land is not transferred in the land office. On 22 December 1951, the appellant has managed to extract grant of letters to continue her administration on the land. So this means that the land is now being shared by the appellant and the respondent, Hock. Okay, so Nurin and Afif, for your information, I will skip the occasion that happened in 1958 because this only revealed in the trial court. Okay, so what happened in 1963 is the land office has subdivided the land that shared between the respondent and the appellants. There has become 2 lots of lands, which are land numbers 40011 and 40022. And the lots that is dispute is land lots number 4011, because after the division of the land, of the original land, the respondent has become sole proprietor for the land lots number 4011, but the appellants continue her position of the said land until the solicitors of the respondent gave her a notification to claim for relief at the trial court and take legal action against the appellant, Phang. During the trial court, the issue has agreed by both counsel that whether there is a legally binding contract or agreement between the appellant and the respondents, because in this case, the appellant, Phang, in her statement of defense, he said that during 1958, there is an oral agreement happened between her and the respondent, where the respondent agreed to transfer the land solely to her, and the appellant pay $500 for the appellant. However, the respondent admit that there is an agreement during the Japanese occupation, but the respondent said that the transfer of interest of the state land is not to her, it is only to her husband. And the respondent also said that that is barred by time limitation. And Phang stated and emphasized that her claim is not about the agreement that happened during the Japanese occupation. Instead, she was claiming about the oral agreement that happened between her and the respondent during 1958, where there is an oral agreement. But the counsel of the respondents stated that the $500 is not a consideration, but it is only a compensation, and the judge has accepted the evidence provided by the appellants, but gave judgment in favor of the respondent because of the inadequacy of consideration. The judge said that because of the inadequacy of consideration, the agreement is void. And because of this judgment, the appellant appealed against this judgment. So there is a question of law that is appealed by the appellant. So the issue now is whether the inadequacy of consideration is immaterial or not to form a valid and enforceable binding contract between Phang and Hock, the respondent.
Thank you, Roy. Now, when we have understood about the material facts of the case, we need to acknowledge the relevant law in this case. Basically, there are 3 things we have to be clear, which are the sources of law and the principle of law related to this case. In this case, the primary sources used are the Indian Contract Act, the Contract Act 1950, or also called the Contract Malay State Ordinance 1950, and few referred cases such as Kedari bin Rano and Atma Rambat, Robertson and Minister of Pensions, and lastly the Alliance Bank and Rome. This case applied Section 25 of the India Contract Act, which stated that agreement without consideration void unless it is in writing and registered, or is a promise to compensate or for something done, or is a promise to pay a debt bear by limitation law. Also, in Section 26 of the Contract Act 1950 stated that agreement without consideration is void. Consideration is something value to either promise or promiser that is usually cash or property, which will be exchanged between the promise and the promiser as the performance. These both provisions are identical, which prove that there is no evidence of fraud in this case. The other provision from the Contract Malay States Ordinance 1950 is the Section 2D, which defines consideration as when at the desire of the promiser, promisee or some other individual has done, or when without doing or does or avoids doing or vows to do or to keep away from following through with something. Such demonstration or restraint or guarantee is known as a thoughtful for the guarantee. Next, I will move to the case referred, which is Robertson and Minister of Pensions. Briefly, the appellant who is serving armed force official kept in touch with the War Office in regard to a handicap of his and gotten an answer dated 8 April 1941 expressing, your incapacity has been acknowledged as owing to military assistance. Relying on that affirmation, he forbore to get a free clinical assessment for his own benefit. The Minister of Pension later concluded that the litigant's inability was not inferable from war administration. Then the court held that as between subject as such an affirmation would be enforceable on the ground that it was planned to tie expected to be followed up on and was as a matter of fact followed up on. So I'm sure both of you still remember the secondary sources, right? So here, in this case, secondary source used is legal periodical, which is Pollack and Muller on the India contract, and specific in Relief Act 8 edition on the page 222, which explain the case of the Administrator General of Bengal and Jugeshwar Roy. The question then reduced itself to whether there was such an inadequacy of price as to be a sufficient ground of itself to set aside the deed. Okay, lastly, we must also know about the principle of law. As we go through the case of Phang Swee against Hock, the only principle of law that is clearly pictured is consideration need not be adequate, but must be sufficient. It doesn't matter if the consideration is not following the market price or inadequate, as long as there is a give and take. Therefore, even though the consideration is not adequate, the contract is still valid and binding.
Okay, thank you for the Nurin and Roy. So, from the issue, whether the inadequacy of consideration is immaterial or not to form a valid and enforceable contract between the appellant and the respondent, the ratio decision for this issue is that the judge said there is a consideration in this case and the consideration need not to be adequate to form a valid contract. So the ratio decidendi of this case that saying there was a consideration is said as according to the definition of consideration is taken from section 2 clause D of the Contract Act. And based on the case of Robertson and Minister of Pensions and the case of the Alliance Bank and Vroom that has been explained by Nurin. When the land was subdivided, the respondent agreed to transfer the land to her in exchange for $500, and she took no further action in the matter until she received the letter. The respondent agreed to sell the property for $500 to the appellant. The appellant also has evidence to support this argument. Ratio decidendi in this case is also that the consideration need not to be adequate, and this is also mentioned in the judgment, and even the counsel of the respondent also agreed with this. The statement of law can be found in section 26 of the Contract Malay States Ordinance 1950, and its illustration are we call A, that show no matter how inadequate the compensation, the agreement is a valid contract. The statement of law also explained in a law periodicals of Pollock and Muller on Indian Contract and Specific Relief Act 8 edition at page 222. And what Westop CJ in Kedari bin Ranu and Atmarambat that has been explained by Naren. So in section 25 of the Indian Contract Act is identical to section 26 of our Contract Act. Here, there was no evidence of duress or fraud. So the decision of the case based on this ratio decidendi is the appeal allowed with cause, and there will be judgment for the appellant counterclaim. Thank you.
Alhamdulillah, we have discussed one case. Hope we will gain something for this discussion. Okay, thank you very much. Assalamualaikum warahmatullahi wabarakatuh.